You're listening to newsstreamingnetwork.com, home of goingsolomedia.com and WGSN-DB Going Solo Network Radio, podcasts, and TV. Welcome to Divorce Coalition Live, a show designed for divorce professionals to enhance the divorce process to prevent re-traumatization of domestic abuse survivors. I'm your host, Jill Kaufman, therapist, divorce coach, and co-parenting expert. You can get in touch with me at info@divorcecoachjill.com and my website at divorcecoachjill.com. The Divorce Coalition is a nonprofit organization dedicated to increasing education and awareness of divorce professionals and process change to create a more supportive and less traumatic divorce experience. We have united top podcast hosts and divorce professionals to create systematic change in the divorce process for domestic abuse victims. With 23.5% of divorces citing domestic violence as a cause, we bring you expert guests, practical advice, and enlightening conversations. Knowledge is power in creating change in the world of divorce with domestic abuse. So without further ado, let's get started. Mediation, arbitration, and litigation processes have pros and cons when it comes to working with survivors of domestic violence. Family law and other divorce professionals can play a critical role in helping their domestic violence clients choose the best path forward. Today, I'm asking my guest, Judge Jorgensen, to share his expertise to help professionals identify best practices for mediation, arbitration, and litigation with domestic violence clients. Judge Jorgensen has served over 15 years as a Superior Court judge in Middlesex County, New Jersey. He spent his entire judicial career in the family division, concentrating on matrimonial dissolutions, custody, support, and domestic violence. Recognized for his expertise in the field of family law, the judge is a frequent lecturer. His reputation among both attorneys and litigants is that of an even-handed and fair jurist. He brings all of those skills to his mediation and arbitration work at the Blick Law Firm in New Jersey. So welcome, Judge.
Thank you. Good to be here with you.
Can you tell us a little bit more about yourself and what you do now?
Sure. As you've indicated, there for 15 years, or a little bit more than 15 years, I had served as a family court judge in Middlesex County. Prior to that, I had a private practice, and I had also had the opportunity to serve as a municipal court judge for 15 years. So for 30 years, I've been dealing with domestic violence from the judicial point of view. I retired from the family court bench on August 31st of last year, so I'm coming up on my 1-year anniversary, and became of counsel with the law firm of Blick Law in Somerset, New Jersey. And in that capacity, I've been doing mediation and arbitration work for family matters as well as other matters, including dissolutions of corporations and things of those natures. So I've had an opportunity to continue having a hand in the divorce process by way of the mediation and arbitration cases that I've had, and it's an ability for me, a chance for me to use the experience that I've accumulated over the years in trying to help the litigants get through the process. Because let's face it, the divorce process is certainly fraught with emotion, and people need to be able to kind of have an accurate assessment as to where things are going to end up. So, but thank you.
Well, thank you. I think you're our first judge on the show, so that's really exciting, and it's great to get your perspective on all of this.
Sure.
So how can mediation and arbitration be successful when there is domestic abuse involved in the case?
Well, as our listeners are certainly aware, the trauma that's involved with domestic abuse survivors is very real, and the ability to try to reach some type of resolution on whether it's a divorce matter or if it's not a divorce, if it's just over parenting or something along those lines, it's the ability to try to level the playing field, because after all, a domestic violence person who's been abused is not in a frame of mind that willingly wants to interact on a one-on-one basis with the abuser. There's that tension that's involved in there, and so with the people that are assisting them, whether they be divorce coaches, whether they be divorce attorneys, there's that ability to try to level the playing field somewhat in the mediation process, because in the mediation process, it's an opportunity for the mediator to try to get the parties to come to some type of an agreement. And the difficulty is when you've got an abused person and the abuser, the feeling is that it's not on an equal basis. But mediation is an ability to try to level that playing field. The arbitration process is similar to a trial. The arbitrator hears the respective sides from both, and then makes a decision, which is then going to be binding on the parties. But the risks with doing the mediation or the arbitration is it reintroduces the abused person to the abuser, and there's ways to try to remedy that, to have in separate rooms or by Zoom or things along those lines. So it's not a face-to-face confrontation, which causes the abused person to have a difficulty in trying to think clearly as to how a resolution can be achieved.
Do you normally ask your clients if that's what they prefer, or how do you decide how to do that?
Well, generally what I do is I don't have the parties in the same place, in the same room. Fortunately, we've got a couple of conference rooms. And if there has been domestic violence that on a case that I'm mediating, we know that in advance. We discuss that with the attorneys prior to setting up the mediation itself. Sometimes there will be a request for, we would prefer to do it by Zoom. That's fine. But if it's going to be in person, I make sure that we keep them from being in the same room. And then I call it the Henry Kissinger thing, where you go back and forth between the two conference rooms in negotiating trying to obtain a positive outcome on mediation.
Yeah, I've heard it called shuttle mediation. But like when you're in that situation, is there any tips that you have for people to make it a more level playing field other than separating them?
Well, there is the ability to, in laying the ground rules as to what we're trying to get accomplished here. We certainly will talk about what happens if we don't have a resolution. And if we don't have a resolution, then the next step generally is going to be some type of court intervention, whether it be what's referred to as a plenary hearing or a trial, in a divorce trial. And that takes an extremely long time once you hit the court system, unfortunately. So in laying the ground rules as to how we're going to work together to try to achieve a successful outcome, we certainly let both parties know the downside of not coming to a resolution. But we also point out the positives for that. So I do spend a lot of time individually with the litigants and try to let them understand that I do understand the fraughtness that's involved with domestic violence, but also that I'm not going to permit anybody to run roughshod or anything like that. So I think it's a calming effect that I generally would be able to have with the domestic violence abused person, so that they're in a comfortable position, knowing that we're really just focusing on moving forward with trying to obtain a satisfactory resolution that is good for the abused individual.
That's that's a good point, and being clear with the rules is really important. I'm wondering if you have any experience as when you were a judge during the 15 years of really successful experiences with victims of domestic violence. Do you have any kind of stories or things that would be helpful for people?
Sure. The Middlesex County is a large county in the middle of the state of New Jersey. And on a weekly basis, at least once a week, sometimes twice a week, my calendar involved just domestic violence cases. We are fortunate in that we have enough judges in the family division to be able to have domestic violence cases every single day. I guess it's not fortunate that there are domestic violence cases for every day, but we're able to move the cases along, and that's a very real concern that the court system has, that these things don't languish. So on a weekly basis, I was handling generally in the neighborhood of 15 to 25 more domestic violence cases. Many times, the plaintiff, the abused individual, was self-represented, and going to court, even if you're represented, is not a comfortable situation. Going to court under domestic violence, having been abused, and looking across in the courtroom and seeing the abuser sitting at the counsel table with an attorney, you get the feeling that the abused individual, self-represented himself or herself, is feeling behind the eight ball, that the system is against her or him. And what I always strive to do was, first off, let them know what the ground rules were, what they were going to anticipate, how I'm going to conduct the hearing, that they are going to have an opportunity to explain in full what transpired, that they'll have an opportunity to ask questions of the other side, that the other side has an opportunity to ask them questions, that they have an opportunity to have witnesses, and then it's the listening process. I think that in large respect, the retired judges that do mediation and arbitration, they've had that listening component that others individuals don't have. As I said, for 15 years, every week, I was listening to the domestic violence cases and developing an understanding, certainly, as to the process. But I think that most of the time, the individuals that came and were self-represented appreciated that knowledge as to how things were going to progress, and also the fact that I was going to listen intently and make a decision based on the facts of the case. I have had attorneys that have represented both plaintiffs and defendants in domestic violence who've indicated that their clients wanted to have them respond to me outside of that particular proceeding, that they were happy and they felt that they got a fair shake, even if I decided against them. But that's an important thing, I think, for that knowledge to go out, because today it might be person A who's the plaintiff, but if the person A hears that the judge is listening and understanding and is going to be compassionate, that information kind of filters out. And so a week from now, when person C comes in, who's already spoken to A, they're a little bit more comfortable in going through the process.
So you're giving so much good information here, which I never thought about, but any divorce professional who's dealing with a survivor of domestic violence, whether it's an attorney or mediator or, a judge or anyone, you really want to try to make that person feel comfortable,
Yes.
and I think allowing them to, or letting them know what's going to be happening, and letting them know they're going to be heard. That's so important in making someone feel comfortable. So I think that's really good information for divorce professionals as they're working with survivors. And I never really thought about it like that, where what you say to them, and, really making eye contact and treating them, like they're important, and developing that a little bit of trust there is really, really important. So,
Sure. And many times the person, when they finally reach the point where they have filed for a temporary restraining order, statistics show that that's not the first abuse, that there's been multiple abuses before that, but this is the first time that they gained the strength to come forward with it. So they want to be able to express themselves in a meaningful setting, which would be the courtroom, as to what occurred. So that's important to let them know that.
That's great. So would you say that mediation or arbitration is better for domestic abuse survivors, or does it depend on the situation?
It depends on the situation. The mediation and arbitration is not something that would deal with whether a final restraining order would be issued. Okay, that's separate. Okay, so you have the act of domestic violence, the person gets the temporary restraining order, and then there's a hearing. And at the conclusion of the hearing, there's a final restraining order that's been issued. The mediation and arbitration would be going forward from that. For example, if the parties are then going to be in divorce litigation, the mediation would be an attempt to have the mediator discuss the matter with both parties, with counsel or without counsel, if they're being self-represented, with an eye towards having them come to an agreement. And of course, mediation, when the parties come to an agreement, they're not completely happy with everything, but they're not completely sad with everything as well. And in a mediation, there is that. Unfortunately, the way the court system works, in spite of having been involved with it for 15 years, the way that the court system works is it's not really geared to having trial day after day after day. And so if a person is looking to get divorced, they may get a trial date 6 weeks down the road, and they have maybe half a day to present their case. And at the conclusion of that half day, they'll then be notified, all right, you're going to come back again in 7 weeks from now, and we'll give you an afternoon for. So it drags on. And typically that is it costs money to try cases. Fortunately, probably 96-97% of divorce cases get settled without a trial. And how do they get settled? They get settled with mediation, where they're both come to some type of agreement. Arbitration lacks that ability of the parties to craft some type of arrangement. Instead, they're presenting their respective sides to the arbitrator, who think of it as a judge, hearing the case and then making a decision after all the testimony has been presented. The advantage of arbitration is it's a lot quicker than the court system, because with arbitration, I do have the ability to hear the case Monday, Tuesday, Wednesday, Thursday, and continuously in that respect. But it's also getting on my calendar much quicker than the divorce cases is on the court calendars. But the arbitration resolved with the arbitrator making the final decision as to how things happen. So in that respect, the parties don't have that input of, well, I'd like to have this over that. It's presenting their respective testimonies. And sometimes the arbitration is necessary when there's been some difficulties, let's say, in the financial arrangements and the tax returns and things of that line. At least in New Jersey, if a a couple has testified during the trial that some irregularities have occurred. For example, at one trial where the court-appointed expert came in and testified that there was approximately $95,000 a year in unreported cash income. Well, that's something that's you're not supposed to do. And the judge is required to report that to the Internal Revenue Service. So sometimes arbitration is a way to avoid that type of thing.
Yeah. So that's a good incentive to get something done without going to court. I'd love to continue this, but we've got to take a short break and we'll be right back.
Very good.
Domestic abuse survivors experience a lack of trust in the divorce and legal systems in place to protect them. Research shows that many report re-traumatization in court and reported that legal professionals verbally threatened them, mocked them, did not give them a chance to speak in court, exaggerated the survivor's faults in court, and provoked them to elicit emotional reactions. In other cases, divorce professionals may be the first point of contact for survivors with the ability to help if they recognize the signs. The Divorce Coalition is a nonprofit organization created to change this experience for abuse victims and survivors through education and awareness of divorce professionals. For more information, go to www.divorcecoalition.com and please support us by making a tax-deductible donation at www.divorcecoalition.com/donate-now. And now back to the show. So did you have anything else to say about the advantages of each? Because I think that was an interesting example of where somebody is really incentivized not to go to court because they don't want, something to be public that they could get into trouble for. So,
sure.
Yeah.
Both the mediation and the arbitration process, I think, are also very helpful because in a trial, I found, and my fellow judges found, that your case is strongest up to the point where you take the witness stand, meaning that things tend to go wrong when you're testifying in a courtroom, and that's taken away, so to speak, with mediation, because you have an opportunity to talk to your attorney, to talk to who you need to be able to speak to in making the decision as to how economically things are going to work out. So both mediation and arbitration are let me refer to it as much more user friendly than the court system. There just is that fear, I think, that many people have entering the courthouse and being concerned that they're going to be placed up on the witness stand and have the other side as an opportunity to cross-examine them. We don't do that in mediation. And in arbitration, both parties are presenting their respective sides as they would during a trial. But it's not as a daunting atmosphere. We're not in a courtroom. We're in a conference room in my office and dealing with it in that situation.
So in arbitration, is the survivor in the same room as the perpetrator, or can you do it in separate rooms?
We can do it in separate rooms.
Okay.
We can also do it by way of Zoom. So
Okay.
to avoid that confrontation. Yeah.
Okay. So in those, I'm sorry.
But in a divorce trial, they're in the same courtroom.
Right. Exactly. Yep.
Yeah.
So it would be preferable, it sounds like, to have arbitration versus a trial.
A trial.
For a lot of reasons.
It is, yes. Unfortunately, when we have had those divorce trials, or the divorce or the final restraining order hearings, where the abuser, the plaintiff, the abused individual, is sitting there at table, and I can just see on their face the fear that they have with the other person being in the same room, in spite of the fact that there's generally at least two armed sheriff's officers that are there, and there's other personnel in the courtroom, the judge, the court clerk. So, but that there's that very real fear, unfortunately, of being in the same place with the abuser, and we can kind of circumvent that through the mediation and arbitration processes.
Absolutely. So do you have any protections for the survivors other than keeping them in separate rooms, but in terms of, the divorce process? Is there anything else that can protect survivors?
In the for the longest time, when a final restraining order was in place, at least in New Jersey, the parties were prohibited from having any contact with each other in the mediation or arbitration process. And the New Jersey courts then came up with a process where the parties could both agree to go to mediation or arbitration. And in order for that to happen, they are going to meet with personnel from the courthouse who are going to explain the process. They're going to explain that at any time the person is uncomfortable and wants to remove from the situation, that can happen. That any time that they feel is uncomfortable and they don't want to proceed with mediation and or arbitration, it will end. So there is a educational component for individuals that are seeking or thinking about going through the mediation process, even though that there's been domestic violence, to have that added layer of this is something that we take seriously, and we're going to accommodate that as best we can. But at any time, if you do feel that uncomfortable, we can terminate the process.
That's really good for them to know and to be aware of. There's so much here, for people to think about and to be educated on. One last question about child custody. In your opinion, from what you've seen, how does domestic violence affect child custody?
Unfortunately, when there's domestic violence and there are children, the children suffer. No matter how much we try to implement ways for them to benefit, the relationship between the child and the child's parent, who's the abuser in the situation, is going to be damaged. Of course, it has to be. And so there's a presumption that if there's a final restraining order being issued, that the custody of the children is to be with the plaintiff, with the person who's receiving the final restraining order. So in that respect, the child custody is determined pretty quickly, that the children will continue to reside with the plaintiff. Now, having said that, there has to be or some format for a visitation process to occur if warranted. There are some times when the domestic violence was so egregious and was in the presence of the children that the defendant it's not warranted for the defendant to have visitation. The defendant has to go through some type of counseling in order to resume having a relationship with the child. Excuse me. And that will be addressed by the court. The visitation itself If it is, again, has been so damaging, sometimes there are some counties that have the ability to have supervised visitation in the courthouse on a Saturday, and we use that, especially when the plaintiff is indicating that there's real concern. Other times, there's a final restraining order that's issued, but it hasn't been in the presence of the children, and many times the plaintiff quite candidly indicates that the defendant is a good parent and is desirous for the kids to still have a relationship with the parent, the abuser. And then it's a system of, well, who can we have to supervise? Sometimes there's a mother-in-law that might be willing to do it, or there's a neighbor who might be willing to do it. And then also sometimes there's no request from the plaintiff that there be a supervisor at all. That rather that it's fine if the defendant parent can pick up the children curbside sometimes, or sometimes it's in the police department. But I generally was not all that comfortable. Well, not all that anxious to recommend that the transfer take place at the police headquarters, simply because it's not really a good idea for children to be having that knowledge that, well, I go to the police station and that's what happens with mom and dad. So the domestic violence is geared to protect the children as well as the plaintiff, but there are ways that we can maintain or reinstate sometimes the relationship that the children have with the abused parent, the abuser parent.
Yeah. So it sounds like the determination of how that's going to work is put on the plaintiff, on the depending upon what they say, or how is that determination made?
One of two ways. At the conclusion of a final restraining order hearing, where the decision has been made by the judge that a final restraining order is going to be issued, all of the terms of the final restraining order are then addressed right there in the courtroom. And sometimes it'll be the defendant who will say, "Hey, I haven't seen the children since the temporary restraining order has been issued. I want, moving forward, I want to have a relationship with the children." And when that occurs, then at least I would ask the plaintiff, do you have any objection to that? Do you have any recommendations as to how you'd like to see that accomplished? And sometimes it's no. Yes, he or she should have a good relationship with the children. And then there's other times where it's absolutely not. The abuser beat me. The kids were in the living room when this was happening, and it's not appropriate. So that's when we start then going back and forth as to how or it's going to be accomplished to have it. Or sometimes it's at the conclusion of the final restraining order, it's the plaintiff who's saying, "Hey, I'd like to have the children have a relationship with their parent, the other parent, and what can we do for that to happen?" Then we'll go back and forth again with the parties on the record. We're not asking them to discuss it between themselves.
Right. I just wonder if, the plaintiff is saying that the children shouldn't have access to the other parent. Do you look for proof that there was something, do you need to have proof before you actually take that step? Or do you just take the word of the plaintiff? That's just
during the course of the testimony, if there has been something along the lines as to the children viewed it, were involved in it, they've been, the other parent has been abusing the children as we move along. If that testimony is present, then the red flags go up, and certainly we're going to have to address Sometimes maybe supervised visitation or some remedies to protect the children. But if there's been no testimony at all like that from the plaintiff, and so this really is a tip for people that are assisting plaintiffs in domestic violence. If there is that problem with the abuser and the children, make sure that that's coming out at least in the testimony, so that there is something for the court to hang its hat on. If there's been no testimony like that, and there's been no indication in the complaint for the restraining order that the children are at risk, or that the abuser is a parent who can't be trusted with the children, then if there's nothing like that in the record, and then all plaintiff says, well, there shouldn't be any visitation at all. That's not as strong as it's in the record, and now I'm going to deal with it.
Very good information. Do you have anything else you'd like to share with our audience?
They also many times when a final restraining order is issued, we have the ability in that final restraining order to deal with support for both the abused person, the plaintiff, and also for child support. And unfortunately, a lot of times the plaintiff is not requesting that. And so, yes, there's an additional tip that I would indicate, and that is when you are helping people go through the domestic violence process, not to be focused certainly on what transpired to get the final restraining order, but then also let's look into the future, what needs to be accomplished into the future. And that would include visitation, that would include I need support, that would include child support. Most states have child support guidelines, so that's a factor of dad's income, mom's income, and running it through to come up with a number that's an appropriate weekly child support. But those are things that typically don't get requested and don't get considered. The main focus, as it should be, is on getting the final restraining order, but you also want to have that backup information. So when the judge says, well, are you working? What's the other side working? What are the incomes? What are the needs? So we can get that early on into the hopper, so that there's a stream of income that's coming in. So yes, look for information. Be prepared to have a request, and prepared to have information about what you need. That is what the plaintiff needs, as well as what the child support might be.
Great tip. I didn't even think about that, but that's a really important thing for divorce professionals to be aware of.
It is.
Well, Judge Jorgensen, thank you so much for being my guest today. To my audience, thank you for being with the judge and myself on this episode of Divorce Coalition Live. If you would like to listen to this episode again, you can find the link at www.divorcecoalition.com live show tab. All of the judge's information will be available in the show notes. And we have a special gift for you, a free ebook called Stop Condoning Domestic Violence at divorcecoalition.com/stop-condoning-ebook. I so enjoy being your host. Again, I'm Jill Kaufman, and you can get in touch with me at divorcecoachjill.com. You can find the Divorce Coalition at divorcecoalition.com, and please like and share our Instagram page at Divorce Coalition page. Join us in the fight to change an abuse survivor's divorce journey. Stay tuned for our next show. It will be in a couple weeks at 10 a.m. on Thursday. And until next time, help us spread the word that divorce needs to change to create a more supportive and less traumatic divorce experience.
Thank you, Jill.
Thank you.